Did you know that at the federal level, it's still technically illegal to try to change the weather without telling the government first? Thanks to a 1972 law, 15 U.S.C. Section 330A, passed after the U.S. experimented with cloud seeding during the Vietnam War. It's a real law currently on the books in the United States of America. I'm Lee Merritt, and this is your weekly legal brief with Lee, the movement lawyer. This week, we'll be talking about two things. First, we'll break down the Supreme Court's decision in striking down Donald Trump's IEEPA tariffs and what it means for the balance of power between Congress and the president in trade law. Second, we'll pull back to the international lens, what I call the full board, and we'll talk about how other countries are wrestling with executive economic power, trade wars, and democracy under pressure. Let's get into it. Under our constitutional design, Congress is the queen of the economic board, the most powerful piece when it comes to money, taxes, and tariffs, while the president is more like a knight, agile, important, but bound by the pattern the Constitution gives him. The Supreme Court just reminded both branches of that design by striking down Trump's sweeping tariffs imposed under the International Emergency Economic Powers Act, or IEEPA. Here's what happened. In 2025, President Trump used the IEEPA, an emergency law meant to deal with foreign threats, to impose raw tariffs on imports from Canada, Mexico, and China, but eventually almost every other country, including a 10% reciprocal tariff on nearly all goods coming into the United States. He claimed that foreign fentanyl trafficking and chronic trade deficits were national emergencies, and that the IEEPA let him tax foreign goods at will for as long as and as high as he chose. Importers, states, and civil society groups challenged those tariffs, arguing that the IEEPA let the president regulate commerce in emergencies, but it does not give him a blank check to create new taxes or tariff schemes that Congress never approved. And in a 6-3 decision in Learning Resources, Inc. v. Trump, the Supreme Court agreed, holding that the IEEPA does not authorize the president to impose tariffs, and that the Constitution reserves the power to tax, including tariffs, to Congress. Chief Justice Roberts wrote that Trump's reading would give the president unbound tariff power, letting him repeatedly rewrite rates and targets by declaring emergencies, and effectively sidestep the careful procedures Congress put into specific trade statutes. Legally, the court applied what's called the Major Questions Doctrine, saying that when the executive claims authority over decisions of vast economic or political significance, Congress has to speak clearly, not through vague language about regulating importations. Now that matters beyond Trump. It puts limits on future presidents of either party who might try to use emergency laws to reshape the economy without going through Congress as designed. On this chessboard, Congress still owns the center squares on tariffs. It can pass laws like the Trade Act of 1974 that delegated limited time-bound tariff powers to the president, but it can't silently hand over our taxing power through open-ended emergency language. The president, in turn, can move aggressively, only within the lanes that Congress clearly draws. When he tries to move like a queen under the cover of emergency, the court has said in this decision that it will knock that piece off the board. In this section, we'll be looking at the international board. You see, the struggle for controls of the purse and the rules of the game is not uniquely American. Around the world, executives have invoked emergencies, national security or anti-corruption campaigns to seize economic and political power, often at the expense of legislators, courts, and voters. For example, in Hungary, Prime Minister Viktor Orban has repeatedly used emergency-style authority to rule by decree. In May of 2022, Hungary's ruling party adopted a constitutional amendment allowing the government to declare a state of emergency or state of danger when there's an armed conflict or humanitarian crisis in a neighboring country, initially justified by the war in Ukraine. Orban immediately declared such a state and began governing under special powers that allowed his cabinet to issue decrees affecting public spending, regulation, and even elections with limited parliamentary oversight at all. Now, international democracy monitors have cited these moves as central to Hungary's slide into hybrid or authoritarian status, where formal elections exist, but the executive dominates both the purse and the pen. And if we're not careful, we could end up sliding in that very same direction. Okay, so here are your moves for this week. Find your state's primary, runoff, and special election dates for 2026 and share those with 10 people in your network. Make sure that they know what ID they need, how to vote early, and how to track their ballot. Third, pay attention to the international stories about trade fights and emergency economic powers, because every time a leader somewhere claims emergencies to bypass their legislator, it becomes easier for our leaders to try to set the same move. Okay, this has been your weekly legal brief with Lee Merritt. Next week, we'll be talking about how courts are reshaping protest rights and surveillance laws, and how organizers can adapt their strategy when the state is watching every move. See you then.